Hi there. My name is Matt. I'm a lawyer, and I'm here to talk to you today about two Supreme Court decisions that were handed down in recent weeks. I'm doing a video. It's okay, you can come out. And go play. Go. What? And those decisions are Bostock versus Clayton County and Espinoza versus Department of Revenue. And I chose these two cases because they deal with issues that are near and dear to my heart, LGBT rights and religious freedom, but also they were cases that were decided in almost identical ways and yet had very different lineups in terms of who's in the majority and who's in the minority. In fact, you will see, as I describe the cases, that only Chief Justice Roberts and Justice Gorsuch were in the majority in both cases. Everybody else, the other 7 justices, switched sides. So, for context, the Bostock case, which you've probably heard a lot about, was the case in which a majority of the court, a 6-justice majority, decided that existing federal non-discrimination laws protect against discrimination on the basis of sexual orientation or gender identity. What the court held, in an opinion written by Justice Gorsuch, which surprised a lot of people, including me, was that protections against discrimination on the basis of sex included protections against discrimination on the basis of sexual orientation or gender identity. And the Espinoza versus Montana case, which you've probably heard less about unless you are someone like me who pays a lot of attention to religion cases, held that a state scholarship program for private schools that allowed scholarships to be used for secular private schools could not withhold those scholarships from religious private schools under the Free Exercise Clause of the U.S. Constitution. Now, these cases were decided in basically the same way. In Bostock, what Justice Gorsuch's opinion did was basically this. It looked at a situation where an employer who was obliged not to discriminate among his employees on the basis of sex had a situation where, let's say, a male employee was married to a woman and a female employee was married to a woman. Not the same woman, different women. And the employer fired the female employee for being married to a woman, but did not fire the male employee for being married to a woman. And what Justice Gorsuch found, joined by Chief Justice Roberts, Justice Ginsburg, Justice Breyer, Justice Sotomayor, and Justice Kagan, was that that was sexual discrimination. If you are punishing a woman for doing something that you are allowing a man to do, that is discrimination on the basis of sex, and that is against federal anti-discrimination law. And it really is just that simple. There is no more to it than that. And you can see how discrimination on the basis of gender identity and sexual orientation fall out of that. With gender identity, it's a little more complicated just because of the terminology used, but at the sort of most regressive formulation of it, if you refuse to acknowledge that a trans woman is in fact a woman and you consider her a man and you fire her for wearing a dress and heels, even though you would not fire your female employee, your biologically, whatever you want to call it, female employee for wearing a dress and heels, you are discriminating on the basis of sex because you are not allowing your quote-unquote male employee to present in a feminine way. And it really is just that simple. I cannot, there's no more to explain. That's what it is. That's what the court held. 6-3 with Justice Gorsuch writing the opinion, joined by Chief Justice Roberts and the liberal justices. Now, the Espinoza case was really just as simple. The Free Exercise Clause says, well, it doesn't say, but it has been interpreted to say that a state administering a public benefit cannot withhold a public benefit to a person or organization on the basis of their religion. So, again, taking the hypothetical, it wasn't a hypothetical, it was a real thing. I, the state of Montana, am administering a scholarship program. I am allowing secular private schools to benefit from the scholarship program. I am denying the religious private schools the benefit of that scholarship program just because they're religious. And Chief Justice Roberts, writing for the majority in that case, held well, that's just discrimination on the basis of religion, and you're not allowed to do that under the Free Exercise Clause. Now, what's interesting, and what I've alluded to previously, is that the lineup was totally different. In Espinoza, Chief Justice Roberts wrote the opinion, and he was joined by Justice Thomas, Justice Alito, Justice Gorsuch again, and Justice Kavanaugh. I'm being very, very traditional and listing the justices in order of seniority, in case you couldn't tell. The dissent in Espinoza was Justice Ginsburg, Justice Breyer, Justice Sotomayor, and Justice Kagan. So we have a situation where we have two cases decided on the same rationale, but somehow only 2 of the 7 justices join the majority in both cases. So what's going on here? Well, the easiest answer is that that Bostock dealt with discrimination against LGBT individuals, which liberals don't like and conservatives are okay with. So their liberal justices said, yeah, we should interpret the statute to prohibit LGBT discrimination because we think LGBT discrimination is bad, and the conservative justices said, well, no, we're okay with LGBT discrimination, so we're not going to interpret the statute that way. Now, that doesn't account for Justice Roberts and Justice Gorsuch, who are considered conservative, but nonetheless, you can sort of eyeball it in that matter. Whereas in Espinoza, the conservative justices are okay with religious schools getting tax money because that's a conservative ideal. We want to promote Christianity and religion and all of the conservative values that are pertinent there too. Whereas liberals want separation of church and state and think that that is very bad, and therefore they just voted against it on the substance. That is a very, very easy explanation to that conundrum. And and my dog is doing something over there. And I give credence to that as far as it goes. As a lawyer, obviously, I don't really have the option of attributing everything to those sort of political allegiances, legal realism, be damned. But what I would like to do is put a little bit of meat on the bones of that sort of simplistic political argument. And the way I see it is everybody kind of agreed. Everybody would have to agree with the basic sort of literal, pedantic, non-discrimination findings, airplane, in each case. The problem comes with the yes, but. And it's a big but. In Bostock, yes, under a literal reading, if you carve up the statute and treat sex as sex, you are discriminating against husbands and wives, or wives and wives, as I described earlier. But let's be realistic. I mean, when they passed the Civil Rights Act in 1964, whenever it was, nobody thought that they were protecting against LGBT discrimination. That wasn't mainstream back then. It was still pretty much illegal to be gay. And if you took a straw poll of every member of Congress who voted on that, not a single one of them would have thought that they were actually protecting against LGBT discrimination. Trans rights weren't even really a thing back then. So let's be, realistic here and look at what actually happened when it was passed. And if you read Justice Alito's dissent, that's basically what he said. He said, don't look at it word for word. Look at discrimination on the basis of sex as a unit and ask yourself what that would mean to the people who passed it. And that's a sensible argument as far as it goes. It didn't work because Justice Gorsuch and Justice Roberts said no. They use the words discrimination on the basis of sex. If you look at what discrimination on the basis of sex actually is in a literal sense, that's what this is, and they're stuck with that. They chose those words. Congress is stuck with those words. If they want to change that, they need to pass a new law. And the conservative justices went with Justice Alito, or 3 of them did, Alito, Thomas, and Kavanaugh. They kind of sort of agreed with that more sort of socially, substantively conservative way of approaching the words of the statute. And it is what it is. And the liberals were fine with saying, no, sex is sex. LGBT discrimination is discrimination on the basis of sex, and therefore it's against the law. And you can see the reasoning in both ways. But the yes, but is determined by your sort of underlying principles and morals and political leanings as to your feelings about LGBT discrimination. I think that's a fair thing to say. Obviously, if I were writing a brief to the Supreme Court or a Court of Appeals, I would not be so blunt about it, but I think that's the reality on the ground. In terms of the Espinoza case, the yes, but is, yes, Montana was discriminating on the basis of religion, but if we require the state to administer scholarships to religious schools, that's going to end up with, sorry, dog, Marble. That's going to end up with the state funding religious schools, and that's bad. We don't like that. That violates the Establishment Clause, perhaps. It's just a very bad thing, and we, as the liberal justices, Ginsburg, Breyer, Sotomayor, and Kagan, don't want to enshrine that in a decision of the Supreme Court as a constitutional mandate. Whereas the conservative justices, Chief Justice Roberts, Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, are fine with it. It's not a huge threat in the constitutional order if we require states to fund public religious schools. And if you read Justice Thomas's concurrence, joined by Justice Gorsuch, he goes so far as to say the Establishment Clause doesn't actually, not only does the Establishment Clause not prohibit this, but the Establishment Clause doesn't apply to states. So if states if the state of Colorado, which is where I live, wanted to establish Catholicism or Lutheranism or Judaism or Islam as the official religion of the state of Colorado, they could do that under the Constitution. That is a minority viewpoint. It's a viewpoint that I happen to agree with, but I also recognize that the horse is out of the barn and the Establishment Clause is not going to stop being applied to the states. Anyway, you can see how those reasonings kind of drawn from the underlying political and sociological leanings, stupid dog, of the justices forced the alignment to shift, with really only Chief Justice Roberts and Justice Gorsuch holding the line in both cases. So, this is all very academic. And I should say that if you read the Espinoza, there were some other issues in the Espinoza case as to whether there was standing and what the actual remedy was. That's less interesting to me than the actual substantive holding that a state administering public benefits to private schools has to include religious schools if they're including secular schools. The other stuff is interesting, but less interesting. I'll just leave it at that. You can go and read. There's like 100 pages of opinions in that case. You can read them all if you want to. I have. So beyond that, what is the real world import of this? Well, another reason I chose these two cases is because they represent two huge flashpoints in culture wars that are going to be played out now as we go forward. Because if you read Justice Gorsuch's opinion in Bostock, there's this little aside where he says, well, anti-discrimination law prohibits discrimination on the basis of sexual orientation or gender identity, and we understand that there may be some religious objections to this, and we'll deal with those later. Like, if somebody has like a religious objection to abiding by these non-discrimination laws, we'll deal with that when it comes up. This is not a case where the businesses at issue are religious businesses. We're not going to deal with that. Similarly, in Espinoza, what's the dog doing? A tennis ball in the pool. Similarly, in Espinoza, a big front is going to be, a lot of religious schools have LGBT discriminatory policies. They don't allow students to have same-sex relationships. Schools have fired teachers for being in same-sex relationships, same-sex marriages. The question now is, well, if we have this constitutional mandate that schools, that states have to funnel tax dollars to religious schools, will the state accreditation standards, which generally include non-discrimination policies, will religious schools be entitled to a variance from those accreditation standards in order to get the money? Those are complicated cases and questions, and I know the answer seems obvious to a lot of you, and the answer seems obvious to me too as a substantive matter. I'm a religious guy, as you know, if you've read my social media posts, and I'm also very pro-LGBT and very liberal and very progressive. But I would remind you that President Obama, liberal hero that he is, made it almost a full term as president of the United States before he came out in favor of same-sex marriage. It wasn't until 2012 that he actually changed his position and said, I am in favor of same-sex marriage. And it was after that that the Supreme Court got there. And this is still a, developing issue. So while I am fully in favor of maximal protection for LGBT rights across the board, I would urge you to think in decades instead of years and recognize that for large swaths of the country, this is still a live, evolving, and developing issue. Marble. Okay. So on that point, again, getting even further down into brass tacks here, this is what's going to happen. I'm going to take a drink of my gin and tonic first, but here's what happens next. Employees of religious institutions or businesses run by religious people will suffer discrimination on the basis of their LGBT status, and they will sue their employees under the Civil Rights Act. Schools, religious schools that have LGBT discriminatory policies will be denied funds meant for all schools by states, and they will sue the states over that. Those cases will start in federal district court, which is the trial court. They'll be ruled upon by federal district judges. Those cases that will go whichever way they go. They will be appealed to circuit courts of appeal, federal appellate courts. Those cases will go however they go. That will repeat itself for a few years, and then eventually the Supreme Court will take it up again. The Supreme Court has not answered that question yet. The question of to what extent religious business owners, religious organizations, religious institutions, religious individuals are exempt from non-discrimination laws is still a wide open question. And if you watch my video on the Lukumi Babalu IA case, you will know that as a general matter, generally applicable laws cannot be violated on the basis of religious convictions, as a general matter. There's flex in the joints here and there. Now, if you watch that video, you might be thinking of another case that almost answered that question, but didn't quite do it. And that is the infamous Masterpiece Cake Shop case. Now, the question presented in that case was the gentleman who owned Masterpiece Cake Shop here in Colorado, in Lakewood. I've probably driven past his shop a few times. He was a conservative Christian guy, didn't believe in LGBT rights, didn't believe in same-sex marriage, refused to bake a wedding cake for a gay wedding, and he was he got himself sorted out by the Colorado I'm gonna mess it up, the Colorado Civil Rights Authority. I can't remember what the actual name of it is. I apologize to any of my friends who are watching this video who might have been involved in that. Colorado Commission on Civil Rights, I think. Anyway, the Colorado Commission on Civil Rights said to him, no, we don't care if you're Christian, you are a business, you are a bakery, you have to offer the same services to everybody in the state, regardless of their sexual orientation, you are violating civil rights laws by denying this wedding cake. And that case went to the Supreme Court, And everybody asked the Supreme Court, okay, does a conservative Christian business owner have a right to defy non-discrimination laws because of his religious convictions? Dog is soaking wet. And the Supreme Court didn't answer the question. Instead, what they found, now she's going nuts. She does this. She's in the pool again. Okay. What the Supreme Court instead held, in an opinion written by Justice Anthony Kennedy, who's not around anymore, was that in the process of administering this guy's case, the state of Colorado was insufficiently deferential and insufficiently respectful of the guy's religious beliefs. And that in and of itself was a violation of the Free Exercise Clause. So they didn't reach the question of whether the guy was right on the merits. They just said, Colorado, you were kind of a jerk to him as you were administering your punishment, and therefore he wins. And as I said before, and people don't like to hear this, but that particular holding, that very narrow holding that a state has to be nominally respectful of, give me the ball, nominally respectful of religious beliefs, even when they are evaluating whether a religious belief entitles the believer to a variance in non-discrimination law, they have to be sufficiently respectful. That holding got 7 votes. Only 2 dissenters, and I'm blanking on who the dissenters were. I want to say it was Ginsburg and Sotomayor. But at least 2 of the 4 liberals, I think it was Breyer and Kagan, joined that opinion. So that's all by way of saying that the actual underlying question of whether and to what extent an individual business owner's religious beliefs entitle them to defy non-discrimination laws is wide open. The Supreme Court has not gotten to that question yet. There are some cases where they kind of tease around the edges, like the Hobby Lobby case on contraception. There's another case coming down probably tomorrow on a group of Catholic nuns who didn't want to have to deal with the ACA's contraception mandate. But I mean, the sort of big question is still unanswered. And here's how that's going to go. As I said, it's going to start in the federal trial courts. It's going to go to the federal circuit courts. It's going to kind of jack around there for a couple of years at least. And eventually the Supreme Court is going to get a hold of it and decide. So what does that mean in terms of real-life politics? Well, here's what it means. The federal judiciary has hundreds of judges. I think about 700 district judges. I don't know how many circuit court judges and 9 Supreme Court justices. 200 of those judges have been appointed by Donald Trump. So a lot of those cases are going to end up in front of Trump judges. And they're probably not going to go the way that liberals want them to. And certainly, if it goes up to the current Trump court, which has a conservative majority, even though Chief Justice Roberts is, waffling a bit, it's probably not going to go that well if it gets to the current court. Now, in the next couple of years, I would say definitely Justice Ginsburg, probably Justice Thomas, perhaps Justice Alito will retire. The next president, or perhaps the current president, depending on timing, we've got 4 months of the election, will be able to replace those justices. And in the meantime, obviously, as federal judge vacancies come up or are established by Congress, the president, whoever the president may be, will be able to appoint those judges. And if you have a particular preference as to how the interplay between conservative religion and LGBT rights plays out, you should vote accordingly. Because the president, after all, is ultimately the person who appoints judges and who appoints the judges who decide these cases. And Donald Trump has a huge head start with 200 judges and 2 Supreme Court justices. Food for thought. The election is coming up. It'll be here before you know it. Please vote accordingly. Thank you for watching, and let me know if you have any questions.